Hello and welcome back to Outer Temple Chambers Ask Us Silk, our quick Q&As with leading practitioners about recent legal news. Today I'm joined by John McKendrick QC, one of our eminent commercial silks, and we are talking about the recent grant of permission in a judicial review to the Financial Services Compensation Scheme's decision about the scope of their investigation into London Capital and Finance. Of course, the demise of London Capital and Finance was big news. The SFO are investigating a number of individuals. Dame Elizabeth Gloucester is leading an investigation into the FCA's supervision of London Capital and Finance. But sadly, for reasons of time, those matters are outside of the scope of today's video. So with that context, hello, John.
Good morning, Victoria, or should I say Kalimera from Greece?
Your background is rather showing up the rest of us on the Ask a Silk videos.
I've got to live up to my reputation as a sunshine silk, so I'm doing the best I can to bring a bit of warmth to our view in grey and possibly wet UK.
So, straight to business, what's the London Capital and Finance Judicial Review about?
Well, this is a challenge by a group of those who invested in this scheme to challenge a decision of the Financial Services Compensation Scheme made in January of this year to effectively limit the scope of the regulated activity, which would limit, in effect, the ability of those who invested to recover from the FSCS compensation for the loss of, I think, around 237 million, which was the sum invested in the various bonds organised by London Capital and Finance. So quite a big challenge and quite a big decision. I think there were something around 11,600 bondholders, and as I say, they invested around 237 million. And by their grounds of claim, the Claimants' Council point out that if the decision of the FSCS stands, the January 2020 decision, really only around about 1% of investors would receive compensation under the statutory scheme. So one can see why they've brought the claim, and I think it is a fairly significant claim, which involves statutory interpretation of the overall statutory scheme, which really begins with the Financial Services and Markets Act 2000, and really looking at two provisions in particular, Section 22 regarding regulated activities and Section 213 regarding authorised persons. And that is fleshed out further by looking at the Regulated Activities Order and MiFID II, the 2014 EU directive. And at the heart of the issue is the interpretation of transferable securities and whether or not they were negotiable on the capital market and what that means. So that's really, in essence, what the judicial review is about. The relief that is sought by the claimants is to quash the January 2020 decision of the FSCS and to seek declarations regarding the proper scope of compensation which might be claimed by those who've lost out to the London Capital and Finance investments that they made.
Great, thank you. And of course, we know now that the claimants have recently been granted permission to bring the judicial review. Which grounds did they get permission on?
Very helpfully, the grounds of challenge are available, and I've had a read of them. I haven't seen the summary grounds of resistance provided by the defendant, but Mr. Justice Murray, in a written decision, has granted permission on all three grounds, and I'll just very briefly, Victoria, talk you through what those three grounds are. The first is a challenge to the FSCS interpretation of transferable securities, as I just mentioned. And that challenge is brought on two grounds. One really based on the context and the language of the legislative scheme and the MiFID definition of transferable securities, but also because this comes from an EU directive on a purposive statutory interpretation, or to use EU language, a teleological interpretive approach to the directive. And it seems to me that the claimants potentially have quite a good case. I haven't read any of the evidence in the claim, and I haven't seen the lines argued by the defendant. But the essential point on the language and context is that the statutory scheme uses the term class of securities. And by using the term class, I think that's quite significant because it's looking at a class of securities, namely bonds. So if a class or a generic term is used, then bonds would be included. The statutory language is not pointing to the individual bonds at play. Now that's significant because in these individual bonds, language is written in which purports to make the bonds non-transferable and therefore not negotiable on capital markets. And that's at the crux of the issue. So ground one is on statutory interpretation with the two prongs of the context and the purpose. And obviously the purposive argument is the whole purpose of MiFID II is to protect consumers. This would create a very significant carve out for consumers from the protections that they are supposed to receive. So it's a very interesting ground of challenge. Ground two is in the alternative that if the non-transfer provisions should be interpreted in the way the FSCS says they should be, that they should not have effect as really a question of private law between the parties to the contract because of the terms of the Consumer Rights Act 2015 and because of the common law. Essentially, I mean, this is quite an interesting argument. What the claimants are arguing is that the judge in the judicial review should essentially determine the rights and responsibilities, the duties under the contract, as between two private parties, the investors and LCF, to determine what was the true nature of the contract between them. Now that really is a private law issue, but it seems to me it's appropriate for the court in public law proceedings, in the administrative court, to determine that, because unless you determine that, you cannot properly determine the issue of whether or not these bonds were transferable securities. Yeah. So it's interrelated. So in public law proceedings, private law issues will be litigated. And essentially what the claimants say is that under the Consumer Rights Act, where there's any doubt about the terms and conditions of the contract, then that should be resolved in favour of the consumers, the investors, and they also say that some of the terms and conditions on the lack of transferability of these bonds are simply unfair and therefore not enforceable. So that's ground two. And ground three is again on the alternative that if the claimants are wrong on 1 and 2, that LCF is still caught because it was carrying out a regulated activity, because it agreed to carry out providing transferable bonds, which would be capable of being used as ISA investments. So, I mean, effectively, the argument is even if these are not transferable securities, that is what LCF agreed to do. And by agreeing to do that, that's a regulated activity. And therefore, these investors and their investments in the bonds are caught and are within the scheme. Those are the three grounds, all arguable, and it will be interesting to see what the court makes of them in due course, Victoria.
Definitely. You mentioned to us a moment ago, John, that the investors that are caught by the decision are only about 1% of those who invested. Why is this decision so important for the other 99%?
The 1% figure I've read from the claimant's grounds. I haven't seen the defendant's response to that, but there's obviously a clear logic in what the claimants say about that, and that's why this decision by the FSCS of earlier this year is so important, because essentially with the collapse of LC&F, and from what one can gather from what the administrators are saying, this is the end of the road for many people. Unless they can get in within the FSCS compensation scheme, they may well have lost a very significant sum of money. It is possible that the government could set up an ad hoc compensation scheme. It did so with, as lots of your viewers will know, with Equitable Life, but it may not. And the government has many, many challenges on many different fronts. So who knows? So this is a very important judicial review for the roughly 99% of investors who currently have been determined by the statutory scheme to be out with any compensation.
So there's a real practical significance then. What's the legal significance?
think the legal significance is whether the FSCS's interpretation of what is a protected investment is correct, and whether in fact purveyors of financial products can bypass MiFID II by inserting non-transfer clause into their instruments. So that has wide-ranging consequences. Essentially, in the grounds of claim, the claimants say, if the FSCS interpretation of the statutory scheme is correct, they are essentially driving or horse and carriage through the statutory scheme by allowing London Capital and Finance and others to avoid the regulatory provisions of the statutory scheme and MiFID II in particular. So the interpretation is important for these investors, but could have wider consequences about the scope and range of protection and those who may be able to obtain compensation.
Thank you. And why are those perimeter issues so important for would-be investors?
Well, in this context, often firms like LCF conduct some regulated activities. So, for example, the promotion of bonds is agreed to be a regulated activity, and LCF were also registered with HMRC under the ISA regulations. So it's reasonable to suppose that some consumers may have thought that the firm's other products would also be regulated, which could create a misplaced sense of security and oversight. In effect, a lot of people might have invested thinking, oh, this is an FCA authorized firm. These effectively are ISAs. Other ISAs are protected, and therefore I can invest my money because I think I'll be protected. And if there's any problem, I'll be able to seek compensation. That's not quite how the FSCS interpreted the scheme, and therefore I think clarity is required, and that's why this decision will be important, because it will provide the clarity to consumers. And no doubt we may well see some changes in the overall scheme, or certainly in the guidance, depending on whatever decision is arrived at by the court.
Interesting. And what do you see the broader relevance of these issues being then? What changes might we see?
There are a lot of mini bonds held by unsophisticated investors. We will see to what extent there may be calls for them to be regulated along a similar way. I'm not sure. From a legal perspective, it will be interesting to see how the court deals with determining a private law series of rights and responsibilities in these contracts to further determine the public law obligations on the FSCS. I think that interaction of private law and public law is very, very interesting. And more broadly, as a public law and a commercial practitioner, I'm very interested to see the intersection of public law rights and private law proceedings, and private law rights and public law proceedings. And this is a very interesting example of that. We've seen that in other contexts. We've seen public law concepts of fairness be used as contractual terms, either expressly or impliedly. We've seen duties not to act in a capricious or arbitrary manner imported from public law into the private law obligations between private parties. So this is part of a dialogue between public law and private law, which I think is very interesting. And more broadly, public law is being used more and more in commercial disputes, particularly against regulators, in a whole series of areas: financial services, competition law, civil aviation issues, education law. There are a lot of issues for regulators that come up as public law challenges, but often rely on private law concepts. So it's a very interesting dialogue between two branches of our common law.
That's great. Thank you so much, John. We're on Zoom, clearly, because of lockdown. I'm calling you from a rainy London. You're in a rather different environment. Dare I ask how lockdown has been treating you?
Well, I spend quite a lot of time traveling internationally, long haul a lot of the time, and that's come to an end, obviously. So I have embraced European travel since July. I had a wonderful week in Venice in July, and then have spent quite a bit of time exploring Greece in August. And I had a whole range of hearings in the Royal Courts of Justice in late August and into September and the beginning of the term before the Divisional Court. But now those are out of the way, and with only remote hearings in my diary, I am making the most, I'm afraid to say, Victoria, of the sunshine, Messina, the tzatziki and the souvlaki here in Greece, but continuing to work furiously with various screens which you cannot see. But yeah, I just need you. How are you? How's wet London? Not too miserable, I hope.
No, it's nice. It's not as good as where you are, but nice to be getting back out a bit more than we were earlier this year. Other than your colleagues, of course, what have you missed the most in lockdown?
I mean, obviously, the great people at Outstanding, as you refer to. I really do miss the chit-chat outside of court, speaking to my opponents and my clients. I enjoy the exchanges with most of the judges. And you cannot really replicate that on remote hearings. I mean, I think I was involved in the first ever all Skype hearing before Mr. Justice Austin in March. So I was easily an early convert because I could see the necessity of online hearings to keep the system going. And in fact, the second hearing I had was a 125 million euro LCI arbitration regarding offtake contracts. And that took place very easily before three arbitrators in different parts of the world, witnesses in Russia. And again, I mean, how would we have done it otherwise? So it was essential that we embraced remote justice, and it's great to see that the civil courts are bearing up very well, and we're able to do this. But ultimately, you cannot replicate the atmosphere, and for me, the challenge and fun of being in an actual courtroom. And I was in the divisional court before the president of the QBD, a judge of the Court of Appeal, and a judge of the High Court at the beginning of the term. And I have to say, it was pretty thrilling to be back in before real hearing, and it was very, very enjoyable. So I've missed that, but I'm very optimistic that in 2021 we will start to get back to normal. But keep some of the good stuff, because there's a lot of case management hearings, pre-trial reviews that can take place by Teams and Zoom. And if that means some of them can be done from the Greek sunshine, I, for one, will be very happy.
Well, thank you everyone for watching. We hope this has been interesting, and we hope to see you soon in real life. Thank you very much again, John, and goodbye.